Thank you, everyone, for coming out today. The talk is entitled Wiping the Slate Clean, Tips and Tactics on How Best to Achieve Settlement in the ET. Really hope you like the title. It took us a very long time to come up with that, perhaps even longer than the actual talk itself. I'm Nick Singer, an employment barrister here at 42BR Barristers.
And I'm Karolina Zielinska. I'm also a junior employment barrister at 42BR Barristers.
Now, this is the first webinar in our latest employment law series. We've got lots of different ones coming up. Ground rules, any questions that you have, please pop into the Q&A box. This will be addressed at the end of the session. Hopefully we'll have enough time to deal with that. And there will also be an email containing the recordings and a feedback form that'll be circulated over the next few days. So the recording is also going to be available on our website and on the YouTube channel. The inevitable legal disclaimer, I should just say, we're not giving any legal advice. Don't rely on any of this for legal advice. Of course, every legal case turns on its own facts. So if you have any specific inquiries about an actual case, we have lots of very good employment barristers here at 42BR, so please be in touch. So let's get on with it. So let's start with the first question. Karolina, what are the benefits of settlement?
So I think the benefits of settlement are going to be something that most listeners to this talk are very familiar with. But just for the sake of recapping this at the outset of our talk, Nick, benefits of settlement are going to be in flux. They'll change at different stages of proceedings. So it is something that people should keep under review. There's always going to be a financial cost to litigation. I think that's fairly trite. But there is, of course, also an emotional cost, particularly as far as claimants are concerned.
So do you have any particular stories, or in your experience, how do claimants find litigation?
I think often the degree to which proceedings are deeply personal can vary, but certainly in cases involving some level of personal injury, disability, that sort of thing that requires extensive medical disclosure, that can be very difficult for claimants to deal with. Sustained discrimination as well, I think, is a particularly personal aspect of the sorts of claims that we often see in the employment tribunal. Yeah. There is, of course, then also an organisational cost, again, particularly to respondents in this sort of litigation. And that comes in the form of the time it takes to find relevant evidence, collate it, ensure the availability of relevant witnesses at the hearing. That can be considerable, and it is linked to financial cost, but is worth considering as a separate head because it could be particularly impactful on a business, particularly small businesses.
Okay, so when do you think is the best time to be thinking about settlement?
Settlement is something that has to be kept under review throughout proceedings, even pre-proceedings. Although engaging can be tricky with the opposite party prior to proceedings if they're simply not willing to engage. And certainly in my experience, quite a lot of claimants prior to getting in the ET1 don't want to talk settlement just yet. Yeah. They just want to get their claim out there, and then perhaps they'll start to engage in those discussions.
So how have you found the ACAS process? Is that useful in your experience?
I think it does add something, but for me, again, in my experience, it tends to be a bit of a binary option. Either claimants engage with it or they just don't at all. And so if you do have a claimant who's engaging with it well, take advantage of that, get those discussions started, get settlement talks ongoing if possible, see what the key points of contention are. But if they're not engaging with it, one simply just has to wait for the next stage in proceedings. I should note there, perhaps, that negotiation is often more effective when one has a pressing deadline looming, whether that's a preliminary hearing, a disclosure deadline. I think that's, again, fairly trite. But the benefit of that is imposing deadlines on yourself can help get talks moving. So, for example, judicial mediation is typically something that is offered to cases that run for 3 or more days at a final hearing after the first hearing in a case. So they'll come just after the preliminary hearing, but at some point typically before disclosure. Now, having that sort of thing booked in the diary can be extremely helpful. In the lead up to judicial mediation, both parties are thinking about the possibility of settlement, and so that's actually a really good time to start those negotiations. You don't have to wait for the day itself. And engaging with something like judicial mediation can be really helpful because, of course, we're avoiding the cost of disclosure. But also, if appropriate, one might consider agreeing a limited form of disclosure to help to resolve certain matters at the judicial mediation. Again, that's going to be a bit fact dependent. I would say in the large majority of cases, it's better to ignore disclosure completely at the judicial mediation stage, just because it helps parties to look forward rather than back. And it means that focuses on settlement rather than arguing over lots of little irrelevant facts that a claimant or a respondent might take particular issue with. But overall, the cost is greatly reduced compared to continuing the litigation. It's usually about £600 for the court's fee, plus cost of counsel in attendance, perhaps the cost of having someone from the business attend who has authority to settle on the day and can be present in negotiations.
Yeah.
And I should perhaps say, actually, in my experience, I've had a few cases recently where the court has been very unwilling to proceed with a judicial mediation in circumstances where there is no one present with authority to settle. Now, a lot of respondents like to have someone available by phone, but more and more judges, in my experience, are saying in judicial mediation that's just not enough. Have you had similar experiences recently?
Yeah, I certainly had a judge say, they've got to be there. I think it makes good sense, because the last thing you actually want is, you're in the middle of the negotiation, claimant's about to walk out, and you get this final offer on the table, and your representative, the person who will actually give you authority, has gone off for lunch, and unfortunately the entire thing falls apart. So
yes,
it makes good sense to me.
And with regards to judges during judicial mediations, I think it's important to explore the role that they actually play in discussions between the parties. So how would you describe that sort of duty that a judge has in a judicial mediation?
I think they're particularly useful when you have a litigant in person. Now, of course, we've all experienced judges. They're very, very different. They've all got different personalities. But I think it's really, really useful to emphasise, as I said, when you're up against the litigant in person, why judges are so important. It's because of their authority. They can be very persuasive with litigants in person. Now, I don't know why, but litigants in person don't tend to trust the lawyer on the other side. We know our duties, but they don't. Maybe it's fair enough. They don't trust the lawyer on the other side, but they will trust the judge. And whilst judges aren't supposed to and don't tend to give their view, that's more for judicial assessment, not that anyone actually uses that, but they're not supposed to give their view, and it's very difficult for a judge to give a view based on papers alone. So I find they don't tend to give it. But what they're very, very good at doing is steering a litigant in person in the right direction. The sort of thing, actually, that you might find if a litigant in person had a lawyer, they might say. So, there are no guarantees in litigation. I've had experience, one piece of evidence killed an entire case, even if it looked good on the paper. Or a judge saying, look, I've been doing this for 20 years. The top award I've ever given is £500,000 in that one case. But most cases come in at 30. So why are you claiming £1 million? Or just simply telling them something, legally relevant, like the statutory cap in an unfair dismissal case. Sort of things which you might want to relay to them if you're a respondent, but they just won't believe you. And I think that authority can really help, a very unreasonable litigant come closer. And even if you don't resolve it, it might narrow the gap. So I've tended to find judicial mediations have been very, very successful, actually.
So in essence, the scope of their role is helping to guide parties towards a resolution by perhaps emphasising what's likely to happen, or what, if they were hearing the case, it might be their experience, but not to provide a solution out and out to parties. That's for parties to come to between themselves.
Yes. So are there any times when you think you're going to struggle to settle? So situations where there's a bit of a problem, why won't you be able to settle it? And what sort of things do you think everybody can do to try and make sure those problems don't occur or solve them?
I'm sure all of us here today have had situations where settlement's on the table, we want to discuss it, but unfortunately the other side's just not engaging, and we don't know how to bring them back to the table.
Yeah.
In particular, I find this tends to happen in cases where a claimant's not provided a schedule of loss. So in these sorts of cases, it can be really hard to know what the starting point is, where the claimant wants you as the respondent to choose a settlement figure rather than provide a reasoned starting point themselves. Now, to get round that, either you can engage with the claimant, ask them more specific questions about what they want to achieve from the litigation, what sort of result they envisage that might help you to choose a reasonable financial starting point for an offer. But the alternative is often that you just simply have to delay settlement until a point at which tribunal has ordered the production of a schedule of loss. It's just so crucial that there isn't really another option there. Other issues I have seen in negotiations that are often prohibitive are that financially it's just not worth it yet to settle. So this is more the case at the start of proceedings where perhaps parties haven't yet incurred particularly significant costs. They're not going to have to for a while. And so settlement just starts to get a bit stale. No one really feels that pressure to get something finalized and agreed outside of the tribunal forum. Yeah. And in those kind of scenarios, I mean, again, I'd be curious to see what your input is on this, but I found a particularly useful scenario is to try and cost it out. So to estimate your own costs, the other side's cost, present them all and say, look, this is what we're heading towards, have a very frank conversation about the likely financial losses on both sides and highlight the benefits of a potential early settlement. And those benefits are, of course, ones that can go further than the sorts of benefits that might be achieved in the tribunal process. That's always a really good thing to highlight. So, for example, things like provision of a good reference, keeping company accommodation or equipment for a period of time after employment's ended, a personal guarantee of commitment to change company practices in the future, reinstatement, moving employees from department to department, promising to deal with a colleague in a particular way. The list is practically endless. But these are all the sorts of benefits that can't necessarily be dealt with by a tribunal, that provide an opportunity for settlement much earlier in proceedings. They're very, very attractive things that can be dealt with at that earlier stage.
Yeah, I totally agree. And I think one of the themes that is coming through from what you're saying is it's about constant communication with your client, communication with the respondent, setting information out and things as early as possible to make sure if you want to settle it, some people I know will be just, we're going to tribunal, that's it. But if you want to settle it, you've got to get all of these things laid out. And actually, interestingly, when you talk about the costing it out sort of idea, for hearing through the grapevine, seeing it sometimes in tribunal, what tribunals are trying to do is to front load directions. I don't know if you've seen it in practice, but the suggestion being that they'll try and get witness statements to come out early. So rather than it sort of be, you have disclosure, 6 month, 10 month gap, witness statements, don't know, front load all the directions, and that puts pressure on parties to settle. Firstly, because of the cost, but secondly, I think attitudes start to harden. As you said earlier, disclosure can start to wind people up when they start reading through the documents. But drafting the witness statement, that is really going to get the parties entrenched, not only with the costs. So again, that really means before the first PH, if you're going to have a judge who's going to front load the directions, really, really important to cost those things out, as you say, but also start thinking about settlement really early.
Absolutely. And I think it's an interesting approach that the tribunals seem to be taking more recently. I suppose then coming back to barriers to settlement, the other one I've seen quite a number of times is the claimant not being willing to engage with settlement on the basis that they want their day in court. I think we've all come across those sorts of cases. My best solution in those sorts of cases is to offer the claimant a similar alternative. So going for something like judicial mediation can provide a forum that's very similar to a real thing, that gives, particularly in the sort of opening plenary sessions, an opportunity to the claimant to be heard, perhaps to read out any statements that they may have prepared at that point, to tell their side of the story and feel heard by the respondent in a forum that doesn't require going all the way to a final hearing. I should note, perhaps in those cases, although it's not always as palatable to respondents, another way of dealing with that sort of day in court attitude is offering a resolution that has some sort of public element, whether that be a public apology from the respondent or some sort of provision of an open reference or something like that, that
Yeah.
can assist with achieving settlement in those cases.
Yeah, I mean, you mentioned all the different options outside of court mechanisms, things like apologies. I mean, I remember in one judicial mediation, spent about 5 minutes on the money and about 2 hours drafting the apology, and we were getting into with heartfelt and these wholeheartedly. What do these words actually mean? And the claimant was saying, "Hang on," but what's interesting, and we forget about it as lawyers sometimes, is we're often thinking about what's the value of the claim ultimately, but to claimants these things can really matter. A judge said to me very early in my practice, and put it in the judgment, that like apologies can make such a difference. Like they can just make someone just feel vindicated, even if it's a qualified apology. Don't lose sight of these facts. They can be very, very cathartic for a claimant. Ultimately, probably want the money, but nevertheless, to clear a logjam.
Money does help, but there are other good options out there. And similarly, in my experience, references have been absolutely key to some claimants. And I've turned up for judicial mediations before, where it's quite clear from what the claimant is saying that they expect that at the end of tribunal proceedings they're going to be given a good reference, and they might actually get a lot of the benefits they're seeking. Whereas perhaps, well, in this case, if they weren't a litigant in person and perhaps have been legally advised, but more generally, there are these misapprehensions as to what claimants are entitled to after tribunal proceedings, and trying to explore other avenues for fulfilling some of the claimant's desires can really help in achieving a settlement that works for everybody, at no great cost to the respondent too.
Indeed, or the judicial mediation having the judge tell them, as we said before.
So talking of costs to the respondent, I think we should talk a bit about schedules of loss and counter schedules, and the evidence we need to support these. They are, of course, vital in helping to settle cases. So perhaps starting with schedules of losses, when should one draft a schedule of loss?
Well, as we all know, when you get to the first preliminary hearing, there is going to be an order that the claimant do draft a schedule of loss. The problem here is that's often many months after issuing the claim. I think if you're in Watford, it might be many years after issuing the claim. But jokes aside, it's going to be a while. And then you have perhaps a 4 to 6 week period to give the claimant time to draft that. And you're into the litigation then, and disclosure orders are coming up. Maybe it focuses your mind, as you said, but on the other hand, have costs started to escalate, have positions started to harden. So I think you should be looking to do a schedule of loss really at the outset of the claim. It can take a while for a tribunal to actually send a claim out to a respondent. Nothing's stopping a claimant sending their claim form in particular as a claim if it's tactically suitable with a schedule of loss. So if you're representing a claimant, I think it's really important to start thinking about the evidence you need to draft your schedule as early as possible. Obvious things like pay slips, what benefits they on, pension information. If you think it's going to be a complex final salary pension, really important to try and deal with that as early as possible. It's going to be extremely difficult to settle a case if no one has an idea of settling. It's going to be 100, 200,000 pounds. No, you've got to start looking at that early. And also medical evidence. Often we're very focused on medical evidence to prove a disability, but of course it's crucial to remedy. So if you're going to bring a personal injury claim or an injury to feelings claim, going to get that medical evidence. Mitigation of loss, if you're going to be pitching a long period of loss of earnings or even career loss, you need that medical evidence to justify it as early as possible. And it is possible to contact the respondent to get some information from them.
Although I should perhaps add, if one is contacting the respondent trying to ask for disclosure prior to it being ordered by a tribunal, I would perhaps always encourage those requesting those documents to say why they're requesting them. So in this case, it's going to help me with producing a schedule of loss. I think that can encourage the respondent to pick up on those requests much sooner, and to disclose what's necessary to accurately quantify the claim. Yeah,
I think actually it's useful as well, because if you've got a stonewall respondent who won't respond to you, maybe it gives you an idea of their attitude, but actually a respondent who wants to settle might say, okay, fair enough. You start a dialogue, and as we keep repeating, starting that dialogue as early as possible is the best way to settle. And that's why ultimately get that schedule of loss out early, because early you can value the claim, as you said earlier. When there's no schedule loss from a claimant, it drifts, and then what are you going to do? I think you've got a greater chance of settling it. But do remember, and we're going to talk about the without prejudice up a little bit later, but just remember about credibility. If you think it's going to change, the one that you're going to send to the tribunal, just be careful about credibility. If you're claiming 500,000 in one and 50 in the other, it's no good. So I say make use of the without prejudice, which Karolina's going to talk about later.
Yes, we will deal without prejudice communication shortly. But you're completely correct. When it comes to schedules of loss, I suppose the difficult issue is how to pitch it. We've all seen very exaggerated schedules of loss. Does it really achieve anything in your view?
Yeah, it's difficult. It's a difficult one, isn't it? Always thinking about it. I mean, the first thing I always say is we will have to manage our clients' expectations. They may well want to go to town. It may be they're very robust. They want to be very aggressive, fair enough, but always be bringing them back to be realistic. Because if a litigant, if a claimant believes they're going to get £1 million when it's never going to be more than 80, you may never be able to pull them back. So always be remembering that. How to pitch it. There's no right or wrong answer. Everybody has a different view about this sort of thing. The client is going to have their own view about that sort of thing. Me personally, I think what you should do is work out a range. So you've got an upper range, a lower range, and then I would pitch it at the upper end of reasonable, or perhaps outside the range of reasonable responses. We don't need a reasonable responses joke, but it's done, it's gone. I think perhaps just a drop higher than the reasonable, so you can back off. But I prefer that. If you're pitching it to a judge, you definitely have to be reasonable. I think that's really important. But I personally do like the starting position that the respondent feels they've got someone to talk to. Again, if you're putting in a £1 million schedule and it's an £80,000 case, the respondent might just say, they're not serious, let's just litigate, and there's just no point in doing that. Depends on what your client wants, but just bear that in mind.
Precisely.
There are a number of other factors. When you put it in, perhaps the earlier, you start being robust and then go down, got to bear in mind credibility, but that the client is going to perhaps have different aims. So it's that question of asking them as early as possible what their aims are. It may be that they're just desperate to settle. It may not be obvious. Maybe as long as we think you maximize it, but maybe some clients think, do you know what? I don't want to maximize it. I can't go through the stress. I just want to settle. Just get that question going early. Who are the respondent? You might be dealing with a respondent, very big employer that gets hundreds of claims a year. They're going to ignore it. They're going to hand it over to their solicitor and say, yep, another one's come in. Solicitor's going to see a schedule, which is grossly exaggerated. They go, oh, joker, goes in the pile, goes on the system, and they just churn it out. They're unlikely to be impressed with that sort of thing. Maybe a smaller company might, if you put a high schedule in, might be a bit more panicked about it. I don't know.
I see what you're saying there. I suppose being threatened with a rather large potential liability definitely will make most small businesses panic. But I do suppose whether one also has to be conscious of credibility. If you're putting forward a schedule of loss that runs into tens of thousands, and then you come in with a first offer that's incredibly low, but say, we'll take this, that can really be quite damaging to the credibility of your case at an early stage. So if you are, I suppose, inflating the schedule of loss to some degree, it's always worth being conscious that your offers are going to need to be proportionate to the sums put forward that you think your case is worth.
Yeah.
And if that's not your intention, if you're just going to come in with a lower offer, really, where's the value in inflating it in the first place?
Yeah, exactly. It always turns on the facts. And also consider, and that does feed into also, I think, what you're saying is who are the personalities involved? Ask the claimant, well, who do you think is going to be the decision maker in this case? If you come in with a really high offer, is that the person who's going to be the managing director of a smaller company? Is that going to generate more heat than light? And the managing director is going to hit the roof. I can't believe this person is claiming that. And that's it. You're done. We're fighting. You're done. So make sure you get as much intel as you can from the claimant as to who's going to be there. It might be a reasonable HR person, such like. And also look into the financial situation of the respondent. Again, any intel you've got, are they struggling financially? Have they got a big pot? How do they deal with settlements previously? I mean, the claimant may have a lot of intel, they may not. You might have a client who's an HR advisor who has knows absolutely everything about it, or who knows. And also do remember, with the schedule loss, put an offer in. It can't hurt. Get the ball rolling. and see where you get. What do you think, Karolina? How do you often advise your clients to pitch it?
Well, it is, of course, incredibly fact specific, but I tend to like to encourage my clients to get as much information as possible before they make an offer.
Yeah.
So that's information in particular regarding what I discussed earlier, those perhaps other factors in the background of a settlement that might actually mean quite a lot to the claimant, trying to scope those out to see whether that can make an offer more palatable to the claimant. What do they really want? Are they looking for money? Are they looking for something else?
Yeah.
And go from there.
Yeah.
So we've talked about schedules of loss more generally. What sort of information would you tend to want to see in a schedule? I suppose we're talking beyond the absolute basics.
Yeah, I'm going to look sort of tactical, strategical 30,000 feet. I'm not going to tell everyone to put the basic award in or things like that and how to calculate it. But one thing I would put in is reinstatement or re-engagement. You often see the box ticked, and you can get to trial, usually with the litigant in person, but get to trial and the judge is sort of saying, oh, are you still interested? Oh, no, I abandoned that months ago, and no one knew, because it can be a real deal breaker. You know, if a respondent, I'm not having this person back at any cost, and maybe if someone ticked the box, or it was a litigant in person who ticked the box and you take over the case. If the respondent's under that false apprehension, then it needs to be corrected, and it can lead to higher rewards. So I think that's worth spelling out. But most of all, what I would say the big thing you need to consider when a schedule is you need to tell the story. It's not just about what the claimant wants, but it's about why the claimant wants it. And more importantly, why is it justified? And I think the more clearly you can lay that out, the easier it is to settle. Of course, with the judge, you're going to want to tell the story. That's crucial for the advocacy, but it's exactly the same for the respondent. If you're claiming a high figure, the judge and the respondent are going to raise an eyebrow. So you need to justify it. So number of examples, a period of long loss of earnings. Well, why are you claiming such a long period of loss of earnings? Not just to be difficult, but because there's a personal injury here. The client's in deep depression at this point, and the respondent needs to know, otherwise it's just guessing.
And when you're setting out that story, I suppose the way that you typically do it, would you include that within the schedule of loss, or would you want that as a separate supporting statement or something along those lines?
I think put it in the schedule. I mean, you don't want it to be 20 pages long and stop reading it, but I think you should be able to tell a nice, clear story within the document itself. One nice document where everything lines up. And if you're making assumptions about pension loss, like the withdrawal factor, you're saying, well, we're not going to allow anything on the basis that the claimant would have been fairly dismissed because clean conduct code record, had been there 25 years, doing really well, business was thriving. Just lay it out, always lay the assumptions out clearly.
So we talked a bit there about schedules of loss. What about counter schedules of loss? When do you tend to see these? What do they sort of tend to contain?
Yeah, I mean, I'm going to start by assuming there are lawyers on the other side. Obviously, if there's a litigant in person on the other side, how you deal with the counter schedule will differ. We can talk about that. I suppose the first question is, do you do one at all? These aren't ordered as often. They're often not ordered at all. And it will be fact specific as to whether you do one or not. And I appreciate a lot of people on this call watching this video are going to have clients who just want to keep costs down. They do a lot of work. And if they do a schedule of loss in every case, it's going to put cost rate up. So I understand that. It's recommended if it's complicated, lay out your stall again for the judge, but also for the claimant. If it's high value, it's the same. And if your client's keen on settling as soon as possible, the earlier you can get out your story in the counter schedule, the better.
Absolutely. And with regards to counter schedules, when in proceedings do these tend to be provided?
Again, I think it depends on your client's aims. As I say, they're not regularly ordered. But if you want to do one, I can't see much benefit in delaying after receiving the schedule of loss. If you get it, like we said earlier, with the claim form, you want to settle it, send one back. I think it helps focus your mind on the evidence you might need. So often we get to trial, we'll both argue the claimants failed to mitigate their loss, you might succeed. And the judge says, okay, well, what would have happened had they mitigated their loss? And you've got no jobs. you've got no job offers that they could have taken. So if you do a schedule of loss, it can just focus your mind on the kind of evidence. You know what your arguments are, start collecting the evidence, like jobs in the area that they could take. Thinking about medical evidence, thinking about whether you need your own medical expert to deal with these if it's a particularly high value claim. One little aside, even if this is about settlement, but even if there's no counter schedule been ordered enough to find, I don't quite know what the respondent's position is on the schedule of loss, usually it's slightly low value claims. Always useful in the brief just to attach a very short counter schedule, even if it's not going to be submitted to the claimant or the court, because it just can save a lot of time. But that's a little tip on the side I thought I would get into to help us down the line.
It does definitely help if one is provided in that way, just to give us an idea of the party's position, regardless of whether it is served. So you talked a bit about how you pitch your figures in a schedule of loss.
Yeah.
How would a respondent pitch their figures in a counter schedule of loss?
Similar exercise. I mean, I often see totally sort of unrealistic schedules. I do accept a lot of the time it's has to be done and it's thrown in at the last minute to keep costs down, but you see an unrealistic stance on mitigation. Should have had a job within a month, 100% Polky reduction, 100% contributory fault reduction, and something close to zero. It doesn't really help with the judge, and it certainly doesn't help with settlement. As I say, sometimes it's a tick box exercise. Knock it out, no one really worries about it, but it's not particularly helpful. So it's the same exercise. Work out your range and then pitch it a notch, maybe 2 notches with a counter schedule below the lowest reasonable. And what do you put in it? It's the same as the claimant. Tell your story. What's your story on reinstatement, re-engagement, contrib, Polky, pension, mitigation, PI, all of those things. Tell your story for the judge, but also settlement. And you know, the ideal here is if you've got a situation where you have a counter schedule with a schedule with a story and a counter schedule with a story, you can have a proper dialogue if that's your aim. So we talked about a situation where we've got a lawyer on the side. How would you deal with it if it was a litigant in person?
So a lot is going to depend on what kind of litigant in person we're dealing with. Some are, of course, far more clued up when it comes to relevant law and how to prepare documents for tribunals than others. But for example, let's say we have a litigant in person with a claim worth around 30k, and they've put $1 million on their schedule of loss. So we know at that point it's totally unrealistic. In those kind of cases, I would recommend focusing on advocacy. So perhaps preparing a counter schedule of loss, as you've suggested, to give the tribunal some guidance as to why certain figures might be unreasonable and what a far more reasonable alternative might be, although of course still pitched at the lower end of realistic. And if that litigant in person seems sensible, engaging with them in correspondence prior to any hearing can be really, really effective. Explaining to them why something is unrealistic, giving them effectively some of the relevant case law or tools that they can then use to make a more realistic assessment of their own claim, which then can form the basis for further discussions.
Okay, let's turn to without prejudice conversations. I should give you a warning. There is case law incoming, but yeah, it wouldn't be a barrister without some case law. We have been very practical so far, and we will get back to practical, and there will be practical things in the talk. But over to you, Karolina.
Thank you. So I think given that we're talking settlement today, it's important to revisit the without prejudice rule, because this is something that is quite commonly misunderstood, but it is a really key factor in having any sort of settlement discussions. So often we will label documents without prejudice, bold, underlined at the start of a document.
In red.
Oh, definitely in red. And I think it's important to dig down into what that actually means. So the without prejudice rule is a rule that encompasses correspondence between parties, whether orally or in writing, that is a genuine attempt to settle a dispute. So the key there is that you must have an ongoing dispute. Raising a grievance is not necessarily enough to say that you already have a dispute ongoing. Those were the words of the Employment Appeal Tribunal in BNP Paribas and Mesotero. So really we're talking about contemplated litigation rather than anything else.
Yeah.
Secondarily, this only covers genuine attempts to settle a dispute. So this is something that the tribunal, if required, will look at objectively. What is reasonably the person who's sending the communication's intention in sending it, and what would a reasonable recipient think of it too. So all of that can help us to work out what communications are without prejudice. They should be labelled as such if you've got any choice in the matter. I'd always recommend labelling any without prejudice communication. It saves a lot of hassle later on. It can be a strong indication that communication is intended to be without prejudice, but it is not technically conclusive. So even if you haven't included without prejudice on a document, provided it meets that test of being a genuine attempt to settle the dispute, a dispute that is ongoing, it may still be covered by the without prejudice rule. Now, whilst we're discussing without prejudice, I think it's also worth discussing without prejudice save as to costs. This is a shorthand that we use to say, well, we're going to consider this communication without prejudice, but we can rely on it later when discussing costs. Now, this is something that's used all the time in civil proceedings, but it's of much less value in employment tribunal proceedings as costs are so rarely awarded, unfortunately. What I will say is it can be quite useful in the fairly limited scenario of if you are for the respondent and you've offered effectively the total amount of the claim sought, so the full amount sought in any schedule of loss, or something very similar to it. Because if the claimant then continues in their claim, effectively all they're doing is racking up costs. And so that is something you can turn around later and point to on the issue of costs in the tribunal. Perhaps then again, a further issue I see arise quite frequently in the context of without prejudice discussions is where a litigant in person has either inadvertently or advertently disclosed without prejudice communications to the court. What do we do in those scenarios can be a very difficult thing to approach.
Everyone starts jumping up and down, and
absolutely.
the judge
Everyone gets
looks
very angry.
Looks very cross.
I think
stare at them. Is that a method?
It's one solution, but perhaps too much intimidation. Not enough legal solution.
No, we need some case law.
Well, what I would recommend to avoid this happening in the first place is, of course, explaining the relevance of the without prejudice rule to litigants in person in particular, as soon as you can at the outset of negotiation. First time you head something without prejudice, it's perhaps a good gateway to saying, this is why we've done that. Make sure that you don't refer to this to the tribunal because it is a genuine attempt to settle and therefore is private, etc., etc. So yes, turning to what happens if the communication is actually disclosed, what do we do then? Well, I think it's quite useful to contrast the approach in the civil courts in these sorts of cases. Their approach can be incredibly harsh. For example, in the case of Balinfanti in 2018, the Court of Appeal made quite a substantial wasted cost order against a party who had disclosed without prejudice correspondence that I think led to some sort of movement of trial dates and consequently led to substantial amounts of costs wasted. However, my view is certainly that in the employment tribunal, quite a different approach will be taken to those who do disclose this sort of communication. I've seen case law to the effect that when considering whether to award costs under Rule 76, considering whether a person's behaviour has been unreasonable, the tribunal has frequently acknowledged that disclosing without prejudice communication is unreasonable, but they're very unlikely to remedy that in costs, unfortunately, unless you can point to a specific effect it had on your case that led to you incurring additional costs. Did it affect a final hearing? Did the material actually come to the attention of the judge and they weren't able to ignore it, and then that led to them having to recuse themselves and all sorts of things? Without those sorts of drastic consequences, it's just not going to have much of an impact. And certainly there's been case law as recently as 2020, not authoritative, but perhaps good guidance to the effect that litigants in person who are found to be unreasonable for disclosing these sorts of materials, even after warnings not to, and even after having the rule explained to them, may still not have cost awards made against them. So the bar's very low, I think, in terms of what it would take to get one of those ordered. Unfortunately, there's just no way that I think it can be met unless some really, really egregious conduct takes place on the part of the claimant.
Yeah, I mean, in practice, where I've seen it, generally speaking, what ends up happening is a claimant starts to talk about it in tribunal, and the judge stop, and you could normally nip it in the bud. I mean, I've never personally seen like a claimant actually write to the judge and say there's an offer. I don't know. I think judges, maybe they're often could be quite good at sort of putting these things out of their mind, and settlement. I suppose it depends on the facts. They expect there to be settlement discussions, but I suppose it does depend on the facts, doesn't it, somewhat?
I've certainly had the odd case where at the start of a hearing, we've had to say, okay, judge, before you look at any of the papers, please don't look at page 42. Please don't look at page 70. Just to avoid communications that have made their way into the bundle, however that may have been. But yes, I think the reality is the tribunal just does not take a very harsh approach to it. And so the best thing you can do in the circumstances is just warn any litigant person or persons not familiar with the rule as much as possible, and hope that they listen.
Yes, indeed.
Not very satisfactory, but there we are.
It is what it is.
So talking then perhaps of settle agreements more generally, I think perhaps it might be good to hear from you on this, Nick. When it comes to actually drafting settlement agreements and sort of COT3s, are there any particular things that you'd recommend we always make sure we include or have particular regard to?
Yeah, I mean, I'm not looking at it so much on terms of the legal details. I mean, I'm sure most people listening that have got the standard settlement agreements and the not going to chapter and verse. I'm going to try and look at it more from a 30,000 feet view again, strategically. So you've got to the point. Hopefully, it's all worked. All our tips have come to fruition, and we're at the end. You've had your protected conversations. You've got the schedules drafted, made the offers, and you're getting there. What are you going to think about the settlement agreement? And here's a few tips. For the judicial mediation, I think it could be very, very useful, and some judges almost order this, to try and actually have a settlement agreement more or less agreed up front. So all you need to enter is or a COT3, all you need to enter is the money. And we were talking about all of those things you mentioned earlier, apologies, references, all these non-monetary things. If you can get those sorted out or get everything agreed, attachments done before we get to the judicial mediation, you have to agree with the money. Because I've often had situations where you get to the money by lunchtime and then actually think, oh, we're done. And then the apology comes up and that takes 4 hours and you have to go home. So the more you can get done in advance, I think that works really very well. I think it's good to have a claimant put a list of wishes together. Again, this is often ordered by the tribunal, but it's like, what does the claimant want? If they're in person, they may not, they as you said, they may not know what they're allowed, what they're not allowed. So I want this amount of money, I want an apology, I want a restrictive covenant removed. And so they put their list of wishes, at least you know what you're dealing with.
And it sounds to me as if really that helps you get that information to be able to explore alternative settlement options, to see what could sweeten the deal that perhaps the tribunal can't offer to a claimant.
Exactly. And it's worth speaking to your client, whether it's claimant or respondent, about these things early. Is there a deal breaker? If you've got a very difficult managing director, I will not apologize ever to that person. It's really important because you could spend such a long time. And if they want an apology and never giving one, don't waste your time and money. As much as judicial mediation is worth every penny, in my experience, it's not if the parties on those softer non-financial issues aren't going to agree. And of course, don't forget the potential tax advantages. Certainly, definitely not, especially given the hour, going to be going into the detail of that. But if it's complicated, speak to an accountant, speak to a tax lawyer, see if you can maximise, if there are any issues about that. I know there's plenty of case law on it, but always remember tax in the background.
And it sounds to me as if, again, that's one of those things that falls within the preparation aspect of any settlement discussions. So get that information in your pocket before you approach the negotiating table, before you have a judicial mediation, so that you're not encountering delays as you go through your settlement talks.
Absolutely agree. So final thought on strikeouts and deposits. Of course, they are a potential tool you can use in settlement to put pressure, and not just on claimants. I mean, often strikeouts and deposits are used to strike out a claim or a little reasonable prospect of a claim. It can be used on a response as well. what I would say is, I say they can be used to put pressure on, but just be careful. They can harden attitudes as well. And if you do go all in on a strike out and deposit when you've got no chance, then a claimant, especially a litigant person, might think, great, well, I'm going to win now. So they can be tools, but use them carefully. Okay, let's finish up. Karolina is going to give 5 of her top tips for settlement, and then we're going to throw it open to the virtual floor, hear maybe some of your top tips or some of your questions before we wrap up.
So I'm happy to say these top tips have been collated through the collective wisdom of our chambers. So hopefully they'll assist you in settlement talks going forward. My first tip would be that if you are having settlement discussions, whether formally as part of a judicial mediation or otherwise, it is always worth getting in touch with ACAS. Particularly if one thinks about the practicality of when you're settling. If it's Friday afternoon, they're not necessarily going to be available by the time you've figured out your settlement. They might have gone home a bit early, and that can actually often be what makes all the difference in coming to an agreement there and then, rather than letting it sit, say, over a week, over the weekend, at which point parties start to get cold feet. So make sure that you've got someone who can assist with formalising a settlement or recording it on the phone and go from there. Secondly, I would say, in my experience, it's a really bad idea to overuse the word final. Best and final offers. If you keep saying it, it loses its shine. So make sure you're reserving those kind of statements for when it really is your best and final offer.
This is a final offer.
It's definitely final this time, you promise. I mean, you've lost all credibility there, haven't you? So save it for when it matters. Thirdly, we talked a lot about without prejudice correspondence today. I would really recommend not mixing without prejudice and open correspondence in the same document. Not only is it very difficult to then separate out what was meant to be without prejudice and what wasn't, but also you've got to go and do a whole lot of redacting, which is just increasing your hours spent on the administrative side of a claim, if you then have to rely on the open part of that document later on. Then further, I would really recommend, as my fourth tip, making sure that the other side doesn't know something's negotiable until it is. So what I mean by that is, if you're putting an offer forward, make sure that you say things like, if you disagree with any of these some sort, tell us why, rather than I await your counter offer. So you're not immediately giving them room to come back at you with a completely different figure. Rather, you're saying this is the figure until you have challenged it for a good reason. Because if you make an offer saying, well, it's open to debate, you've already, again, lost all credibility in standing there at the negotiating table. And my fifth and final tip, I will give credit here to the mediation team at 218 The Strand, with whom I trained a while back for this example. I think it's a really fantastic example. But it's always worth thinking outside the box to try and find a settlement that is acceptable to everyone. So the example that was given to me was that of the mediator's orange.
Fruit examples, always good.
Healthy.
Yes.
So if you have an orange, if you were to split it in half, 50-50, that is legally fair. But what if actually the reality is I really want the peel for whatever reason, and you really want the fruit inside? We don't know until we've entered into a dialogue, until I've got more information about where you're coming from, what your aims are, what you seek to achieve, and what you want going forward. And so really it's important to try and expand on things like a list of wishes, or just get more information about all the parties involved in a dispute at an early stage as possible, so that one can explore those alternative options for settlement that might actually be more effective for everyone.
Excellent tip. Ending on a fruit example works very well.
So with that, I believe that we opened up the floor to questions at the outset, and we said we may well answer some of these if we have time at the end. We've got a few minutes now, so we're just going to check our emails and see what's come through and go from there.
Okay, let's have a look. So the first question I've got here is, should a respondent be more minded to settle a case that relies on privileged information, e.g. someone dismissed from a privileged internal investigation, given they will struggle to rely on that info in a tribunal?
I should perhaps add, of course, that the privilege can always be waived if both parties are amenable to it. It is not a full stop. It can still be revisited in appropriate scenarios. So I suppose it might be worth establishing whether a claimant is amenable to making that open correspondence and going from there before you jump straight to settlement in those sorts of cases.
How do you advise respondents in sensitive cases? I don't know if that is actual sensitive cases. I think it is, where a respondent desperately doesn't want the publicity from it, as it will shine a light on embarrassing internal issues. How can they manage a case if a claimant is very happen or even wants to go to court and therefore feels they have a lot of power? Well, in a case like that, I mean, it's first thing it seems what is being said is here there isn't going to be any chance of settlement, any chance of confidentiality in a case like that. So if you're going to tribunal, I think really going on relevance is going to be really, really important. You know, look, if the respondent has acted in a bad way and they can't settle it and they can't get a confidentiality agreement, and it certainly doesn't sound like it's likely to be a case where you could get any kind of privacy order, because of course the principle of open justice is very, very important. Going to just have to try your absolute best to make sure that, you know, if it's not relevant to the issues, just keep hammering back on it, look very closely at the case law on what sort of issues and how credibility links in with that, and try to sort of maintain control of the narrative as it goes through the tribunal.
I should perhaps add, actually, often claims are pleaded in the alternative. If you're facing that sort of a scenario where you don't want publicity, but one option is perhaps less damaging than the other, if you know that the facts are likely to be made out, and that is why it's likely to bring adverse publicity, it might be worth considering whether you can end up in a situation where you concede a lesser claim rather than deal with arguing over the larger, scarier one in terms of publicity.
Yeah, yes, conceding I suppose it depends on what basis as well. Will you need to will the tribunal need to make findings of fact in any event for remedy, causation? But yeah, I suppose it depends on the facts. Right, for high value cases that justify a payment above the cap, how do you advise both claimants and respondents to respond? How have you seen reinstatement being used as a tool to enable payments above the cap? I have to say, every single time this issue comes up, I have to look at the case law. I can't. There is a very complicated case law as to how the cap interacts with reinstatement and re-engagement, and there's case law which says you can't have it. There has to be a certain amount that's given, and you can exceed the cap in certain circumstances. And given I have to look it up every single time it comes up in tribunal, I ought not to advise on it now, unless this is something you've dealt with recently, because I haven't had to look at a case that I haven't dealt with reinstatement and re-engagement very often. It's a very good tool for a claimant. I mean, that you know, it's a lot of claimants give up on reinstatement and re-engagement, but if it's not going to settle, I think it's always useful. I mean, I suppose claimants don't want to say it if they don't mean it, but if they want to go back,
I'm more cynical. I think it does often get used as a tool to just enable certain types of compensation. But I think when one looks at actual statistics, the amount of times that it is actually ordered as a remedy is incredibly small.
It is, isn't it? Yeah.
I'm relying there on a legal action group employment textbook figure that is probably some years out of date now, but I suspect it's still correct.
Yeah,
it is a very rare remedy in practice.
I had a judge say that the other day to a claimant, actually directly, don't bother with that. Quite helpful to us.
Direct, yes. Well, yes. So I've got another question here. What's your view on claimants having without prejudice settlement discussions directly with their ex-employer with no lawyers in the room?
And I'm assuming this means that there are lawyers instructed. I mean, I don't, obviously it depends on which lawyers and who's instructed and when. I mean, I can't see any justification for this where if everyone's got lawyers, I'd be very, very nervous about sending my litigant into a room to negotiate directly. I'd want to know what the benefit of that is. It doesn't strike me as the best idea. I mean, I did have a case where, where they knew each other quite well and both had lawyers. I was involved and they were like, look, honestly, warned that my client, are you sure? No, look, I really need to have a chat with this guy. Like, I really need to. And do you know what? We settled it. Like, he had the chat in advance and then we went to judicial mediation and they hashed a few things out and we settled it. So I think it's very, very fact specific. It makes me very nervous, very, very nervous. But if it works, okay.
Yes.
Because I should be taking a note, a very careful note of what's discussed.
So on taking a note, I think particularly in a scenario like this where the both sides are perhaps litigants in person, I would recommend that, I suppose, regardless of what note is taken of the meeting, that ideally you have some way of evidencing the intention prior to the meeting that it was intended to be without prejudice.
Yeah.
Whether that's in an email correspondence saying, look, we genuinely want to negotiate with you, would you meet us at this time, etc. I think that covers your back to some degree.
And as long as it stays without prejudice, then it does help. But of course, I can imagine it derailing discussions. You know, the reason people instruct us is to take the heat out of it. But again, it's going to depend a lot on your client. The last question we've got at the moment: have you had any experience of compulsory dispute resolutions? I haven't, no.
That's a very interesting question, though. I haven't had any personal experience with it, but I've certainly heard a lot of discussion about whether it's something that ought to be a thing or not. Because of course we do have compulsory dispute resolution in the form of ACAS conciliation in the tribunal. I think you'll find mixed commentary on whether people find it effective. Certainly, I'm quite a big proponent of mediation being encouraged but not imposed, because there are definitely scenarios where it just won't work, and one would hope that those are fairly limited, but it's not suitable for everybody. I don't think we have time to go into the detail of the sorts of people who it does and doesn't work for now, but that's why I think on a personal level I'd shy away from any sort of compulsory dispute resolution. I'm not sure whether this commentator meant in a contract, perhaps some sort of arbitration that's required.
Perhaps. I mean, obviously, our experience is ACAS. It's compulsory to an extent. It's compulsory to get a certificate, and that's it.
But as we've said, not everyone engages with it meaningfully, and that is just the reality.
It's rare. I mean, I mean, in the employment context, I think it's rare, particularly if it's in person. And we've got one more question here. If a claimant, litigant in person, is being unreasonable in 1, asking for an excessively high settlement sum, 2, asking for an apology which would amount to an acceptance of liability, is there a point in trying to engage in mediation, hoping that a judge will ask the claimant to be realistic, or will you simply annoy a judge? Well, you shouldn't annoy a judge, because a mediation will be by definition without prejudice, and the judge who does the mediation won't be the judge who deals with the final hearing. So there's no issue there. Is there any point in engaging in mediation?
I think in those circumstances, I would say yes. I've certainly had judicial mediations where the claimants take quite an unrealistic stance. And this is what we discussed before, really. The judge acts as a sort of, they provide their own experience to both the claimant and the respondent. And if one side is being particularly unreasonable, they will say, well, look, chances are in these sorts of cases, what I tend to see is X, Y, Z. And even though they won't go out and say, in this case, you are being unreasonable, in this case, we do not think you will get this amount of money, they will definitely nudge a party in the right direction if they are being particularly unreasonable. And I've had offers drop substantially throughout the day.
I always think it's worth judicial mediation. I've done lots of them, and I would say I think nearly all of them, like 95%, settle there or soon after, and the odd one that hasn't settled later. It's very, very high success rate.
Yes.
And as you say, I've often had situations where things change, and they change late. I mean, sometimes you get nowhere, and 3 o'clock it changes. It's everyone's just had enough, or and sometimes it does work. So I'm very in favour of judicial mediation. I think it often works very, very well. But you have to judge the people involved.
We've had another question come in, which is, do you have any suggestions for promoting settlement where the ET1 and 3 go in and the preliminary hearing is listed so far away? We're way off judicial mediation being agreed, and so negotiations stagnate. I think in those scenarios, really, it's on the parties to create their own interest in settlement. So perhaps a good place to start, where we've got lots of time before the preliminary hearing, might be to reach out and say, look, let's get a better idea of where you're coming from in your claim, to assist with perhaps presenting the case to the court at the preliminary hearing. You can use a sort of flimsy excuse like that to open those discussions, because really what you want is the meat of the information from the claimant or respondent. What do they want to achieve?
Yeah.
What might they be able to offer? And go from there. If you have multiple emails that have been sent and you're not getting any response, don't just stop trying, but particularly as it gets closer to any scheduled preliminary hearing, assuming that because they hadn't responded before, they won't be willing to respond now. It's always worth continuing, keeping going, keeping those channels of communication open. And
make an offer.
Yeah, make an offer.
Make an offer. I mean, you go around and say, you go, we were discussing earlier about chicken, like, if someone go first,
Yeah.
put in your, if you're a claimant, put in your, as I said at the beginning, you're above realistic pitch, and I appreciate you won't want to bid against yourself, but if they don't come back, they don't come back. But that might be a way of forcing it. We have a question from Michael Salter. So it's another barrister in Chambers and part-time judge. So we've no guarantee I'm going to answer this one. It's probably going to be a question about international jurisdiction or something quite complicated. I think the reference to mandatory ADR is the practice. Right, so we've got some information here. The practice growing out of the West Midlands that all cases listed over 5 days are, after exchange of witness statements, given to an employment judge to give a steer. It's like a judicial assessment, but with a bit of force behind them. Okay, all right, fine. I'd not experienced that, but
I've not come across it before, but it seems to me to fit somewhere between judicial mediation and a judicial assessment. It's a sort of hybrid, really.
I'd be very interested to see how they work in practice, because we were discussing earlier about the exchange after witness statements. So you're looking at a situation where all the costs more or less have been incurred apart from counsel's brief fee. The parties are going to be very, very hardened because they've gone through disclosure, they've read everything, they're in advocacy mode. But I would be I suppose if it's like a judicial assessment, it gives you that ammunition, doesn't it? It gives you that ammunition where maybe you've got a intransigent claimant and he's saying, this is a disaster. We're going down costs. And if a judge says it to a claimant, this is going to be a disaster, maybe. So, I mean, look, any opportunity to settle it, and things settle at the door of the tribunal as well. I think that these things really, really work, rather than getting to day 3 of a tribunal and watching your case collapse.
I think we've got one final comment here. I can see it says the individual who asked about compulsory conciliation may have been referring to dispute resolution appointments. I will confess, I think my experience of these in the tribunal is fairly limited. I've come across this in the context of civil litigation, and I think I would agree that it's not always that effective. Again, I suppose I come back to my own comments on compulsory mediation generally. I'm not convinced it always works, but certainly in the experience I've had, one case at a DRA where essentially key issue between parties, which might have reduced financial liability by, let's say, 15 grand either way, came down to a bit of case law, and each side just disagreed on the interpretation of the relevant case law, and we did actually really just need a court to settle it. In those sorts of cases, mediation can only achieve so much, but I think at least going into these sorts of appointments with an open mind can be really beneficial. It might be that actually throughout the course of the day something comes up that completely changes the position. I've gone into mediations before thinking that we had a really strong case, and actually something gets raised by the other party, look into it, you realise, oh no, actually that completely changes the balance of liability here. Or perhaps something is revealed that is very harmful to one side's case, and then again that ensures a prompt settlement. We just don't know until we've gone there. So it's worth, if you're forced to go to these sorts of appointments, at least trying to engage with them so far as possible.
Yeah, it's dialogue. So I think that's one of the themes we've had. Right. So we're 7:05 6, so we've kept a pretty good time, which is very, very unusual. I think we're out of questions. We haven't had any we had some comments and some useful. We haven't had any top tips from you, but maybe they'll come in.
Hopefully
Maybe they'll come in later. We can add an addendum, but
yes, yeah.
But yeah.
Well, hopefully you did find our top tips useful regardless. Thank you very much all for attending. Any further questions, if they've come through in the last few moments, will be followed up after the talk by email. If you are watching the recording and have any questions, you're always welcome to reach out to the employment team at 42BR Barristers. I reiterate, this recording will be available shortly online on the YouTube channel and on the Chamber's website. We would be grateful for any feedback you may have. The next session in our employment webinar series will be taking place on Tuesday, the 22nd of October this year, where Nick Bednall-Edwards and Safia Thiru will provide a review on whistleblowing law for detriment and dismissal claims. So please join us at the next webinar. Thank you very much for listening today. And thank you, Nick.
Thank you. Thanks a lot. See you.